Thank you to everyone who is joining us today. I'm my name is Gary Goudelock. I'm Assistant City Attorney with the City of Des Moines. We, and my co-panelists today are John Fatino from the Whitfield Law Firm and Tom Hillers from Hillers Law. We're going to be talking with each other, but for the benefit of everybody on the call, hopefully, and not just for our own benefit. But we're going to talk about kind of, considerations that um, that contract drafting, ordinance drafting, considerations from the litigation perspective that might play into that, and then also in the litigation realm, what consideration do we take from those drafting um, phases, and what lessons can we learn from each other? So just by way of a little bit of background, I'll let John and Tom give their own introduction as well. But for my part, I've got a background both in litigation and on the drafting side of things. I'm currently an assistant city attorney for the city of Des Moines, working mostly doing economic development, land use, zoning, planning, those sorts of things. But in a previous incarnation at the city of Des Moines, I was in our litigation division for 7 years. And then in private practice, I've also worked doing litigation and more on the drafting side of things for some smaller cities as well. John, do you want to give everybody a brief introduction?
Sure. 1991, Drake grad, Whitfield Netty, most of my career. A lot of litigation, but I'd say the older I get, the more it seems that I'm moving into transactional work. And I've had the privilege of trying cases that have fallen apart based upon perceived drafting problems, or at least had to be tried to a jury. And I currently serve as the city attorney for the city of Van Meter. So thank you for having me.
Thanks, John. Tommy?
Yeah, so my name is Tom Hillers. I've been practicing for 17, I think I'm in my 17th year now, and primarily litigation all those years. I am city attorney for 12 rural towns, primarily along the Highway 30 corridor. That's me.
Awesome. I would also add just Tom's got a background in-house practice that had some drafting background as well, and John has a background in the Legislative Services Agency doing some statutory drafting as well. I think those are both relevant to our conversation today too. So um so I think one of the things that I think is worth starting out with is when we're talking about drafting ordinances, for example, we mentioned having our audience in mind for the ordinance that we're drafting. And I think when we were getting our talk together here, we came up with maybe 3 or 4 different potential audiences that we need to keep in mind for drafting ordinances. John, do you want to talk about kind of the council and the mayor first as one of the first audiences for ordinance drafting?
Sure. I think the first thing that I think is important is the first group of people you have to satisfy, I guess, for want of a better word, are the mayor and the council, because you have to be able to take what you heard at a prior meeting, build it, and then be able to report back to the mayor and the council in clear and concise language. Is this what you had in mind? Because clearly, if they're going to adopt it, you have to make sure that you did what they think they're going to do. And Gary and I have worked together for years. And when you sit there in these meetings and you're like, why am I sitting here? Well, it's because you need to hear the dialogue and the nuance that goes into it to make sure you've correctly captured it, is my take.
Yeah, Tom, what do you think about drafting first for the council and the mayor?
Yeah, I think one thing to keep in mind is that the council and mayor that you might be dealing with this session might not be the council and mayor you have down the road. So while you could have a very sophisticated council and mayor, that might change over time. So the way you draft it, you want to make sure that perhaps individuals who are less sophisticated down the road are going to know how to operate within that ordinance if it has procedures and processes in it.
Yeah, and Tom, that reminded me of another thing that you mentioned when we were talking about this before, about drafting with the council process in mind. Do you want to kind of pick that up and talk about that a little bit?
Yeah, I think it's important as you draft it, if you're going to put, say, due process in it, you know, if you're going to have a hearing, notice in a hearing, et cetera, that as you write the ordinance, think about the flow of the ordinance. So I think all too often we have this way of drafting ordinances where we put the purpose first, and then we put in something about whatever issue we're trying to address, the substance. And then we sprinkle in some notice. Maybe we have another definition section. Then we have a procedure, and at the end, perhaps there's some sort of penalty. But when we put this in front of a city clerk, who's going to be the one who, carries the water on it, it doesn't make any sense to them. They have no idea what to do first and second and third. So in drafting it, put yourself in the shoes of whomever at your city is going to be the one who does the work on it day to day, and think about a process map. So who is going to do what at what time and in what order, and then draft your ordinance accordingly so that it becomes more of a checklist for them rather than an attorney's, treatise on the law on that topic.
And John, that's I wanted to ask, based on what Tom was saying there in terms of thinking about the process, are you, when you're putting an ordinance together that has some due process steps in it, hearing, notice, those kinds of things, are you thinking about further like judicial litigation as well when you're putting those together? And if so, how do you take that into account?
Well, I think it's maybe the second step is, once you've made certain that, you've captured the essence of what the council and the mayor are thinking, my next step is always, how is some judge going to wade through this? Is it consistent with like other procedures that are in place, like the municipal infraction statute, just for instance, or the other thing here, and maybe it's a little later on in my notes, but how does this thing look and operate with Exhibit A on it? I just think when you go from drafting to litigation, you just have to keep coming back to that. How does this thing look in court? How does it look and feel? And I think the judge is certainly, once you've gotten through the municipal actors, then you've got to take it to that next level. How is a judge going to look at this? How is a jury going to look at it? Maybe not on the ordinance side for a jury, but I think that's got to be the next step in your thinking.
Yeah, and I think I would add to that too, that when we are coming up with processes and procedures that are contained in an ordinance, making sure that it's processes and procedures that will be followed. Because I think we've probably all seen where there's an ordinance that has specific notice or hearing provisions or other specific processes and procedures that are supposed to be carried out. And then if they're not carried out the way they're set out in the ordinance, then that can come back and bite you. And I think it's, since we're kind of in control of what those are, I think keeping in mind, are these steps that we can and will follow to make sure that you don't get snake bit by your own ordinance.
Sure.
Tom, one of the things that you mentioned before also was about drafting for the citizens and drafting to reading levels. And I think that's part of why I brought up your in-house experience, because I think when you had that experience as well, you were really conscious of drafting towards reading levels and things like that. Do you want to talk about that as part of your drafting process?
Yeah, so part of my life has been, I was in-house counsel at Nationwide Insurance, and I worked on a team that they put together to take all 11 companies that they had bought over the last 30 years and meld them into one company. So all the same processes, all the same policy forms, et cetera. And it was a colossal lift because, as you can imagine, every different group was entrenched and thought that their process and their form was the best. One thing that we always fell back on was we want to use the absolute simplest language possible, because your audience out there typically is an agent. The agent is typically the one who's going to read the policy for the insured and interpret it for the insured and tell the insured, yes, you have coverage. No, you don't. Yes, you met a condition. No, you didn't. And the statistics were that the sophistication of agents had been kind of slowly dropping, in terms of, you had, in the past, you had agents who had been agents for 40 years and they had come through and gotten their certifications, et cetera. And now it can be more of an entry level position for personal lines. So they wanted it drafted to a 7th grade reading level, which they had a system to be able to check that, which was similar to a much lower standard than what Chat GPT is, but something like that, where the language would go in and it could be tested for that reading level. And you're always trying to draft to that, to the most simple terms possible, so that, one, the agent could understand it correctly, because if they didn't, it was going to lead to conflict. Meaning, if the agent reads it, gets it wrong, the insured gets that interpretation, and they say, well, the agent told me this, that has to be the law, that has to be what it was because my agent told me that. Then it led to conflict between the carrier and the insured, when the carrier says, no, that's not the correct interpretation of that language, or it drove some ambiguity into it. So our primary focus was always simple, unambiguous terms, to try to avoid that conflict. Now that can be an analogy for us in working with municipal ordinances, because we oftentimes, when conflict arises with our ordinances, the first thing they do is the citizen's like, I want a copy of the ordinance. And if you're sending something out to them that we have a hard time interpreting, it's going to cause conflict with them as they interpret it however they think it should be interpreted. Whereas if we use simple terms, and if we define our technical terms, define it in real language that applies to real world situations and what we might encounter, that can avoid conflict, because as they read it, they understand it, and they know our position is strong because of that language. Now, whether or not they're going to be reasonable, probably not, but at least it avoids that conflict out of the gate with a lot of those people, when they can see we have a very clear ordinance on file, or on codified.
Thanks, Tom. John, are you thinking of those along those lines when you're preparing ordinances as well? Are you thinking about, I guess, not only the citizens who are going to need to read it, understand it, know what's expected of them, but also I wonder, about city staff, and them being able to understand and enforce it. If it's a zoning code issue or a building code issue, things like that, making sure that they're clear. Are you taking those kind of things into account when you're drafting ordinances?
Yeah, I would say for sure that one of the things that I've got in my notes here is this enforceable? Either from a due process perspective, can you actually explain this to the judge? Or like you indicated a second ago, Gary, am I going to make some complex procedure that then the mayor is going to say, well, we're never going to follow that, And so
Yeah.
to what point, So I think at the end of the day, one just has to keep coming back to is this arrangement enforceable, be it through due process? Does staff think this is actually workable? So I think you always just have to have that in mind.
Yeah, one of the things that I try to do both, and I think, we've mostly been talking about ordinances, but I think a lot of what we're going to talk about applies to contract drafting as well. So I think we might as well open it up to that discussion as well, for contracts, because we probably draft more contracts than ordinances, but maybe not. One of the ways that I do that a lot, I use a ton of defined terms. Do you guys find yourselves using defined terms a lot more as you're drafting to make it clear, or do you stay away from them? What's your thoughts on that?
I'd say for contracts, probably more defined terms. And for ordinances, only because it seems to already plug into the machinery of either the ordinances itself, city code, or the state code. I might have
Hmm.
those terms already defined, but for sure I want to double check.
Yeah.
You know, that's my
So,
thing.
yeah, and that's one of my suggestions that I had on my list. I've had the pleasure of trying to a jury over 3 days a case about a service line, a water service line, and a lot of it turned on. In fact, primarily the conflict could have been resolved if our ordinance more clearly defined where the city private break was at for who's responsible for private service lines coming off of a water main. So I think it's a good example that when you're drafting, you should put yourself in the judge's shoes and draft to those more common scenarios so that you can anticipate those conflicts and draft specifically to it in terms of, as an example, in that case, where does the private service line begin? And I've got that case, a similar case right now that we're in the middle of litigation for, about specifically where does that private service line start in relation to the main, if there is a corp stop on it, or if there's not a corp stop, or in relationship to the curb stop, and thinking about breaking those down into granular definitions so that, in fact, I would say, I don't think you can be too granular when it comes to definitions, because in my experience, they're almost always going to help you the more defined that you are, because then in your motion for summary judgment or whatever it is, even in a jury instruction, you can put it directly in there as a clearly defined term rather than having to call in an expert from the industry, which can be very, very hard to find. Somebody who wants to come down, sit on a stand, and just tell you what a technical term is. Even if you pay them, all the money in the world, there aren't very many people who want to do that for you. So your definitions can foreclose that for you, so you don't have to go through that process.
Tom, you raised several interesting things that I want to follow up on. I'm going to try my best to remember them all and make sure that we touch on them. I think I want to start with the last one because I was going to ask you, in the cases where you've litigated that issue of like, where does the city's responsibility end and the homeowners begin, that sort of thing. So in that case that you tried, did you have an expert? Did you have to call in an expert to testify in that case about that issue?
Yeah, and when you're on the city side, to some extent, you're rolling the dice with your public works person. Depending on your city, obviously, in some cities, you may have an engineer who can come in and testify for you. In other cities, you may have a third-party contractor that does your inspections for you, who can do a nice job. The ones who do them around the state can do a nice job for you for that. But for most of us who represent small municipalities, you're talking about a guy who may even work part-time, and he's worked at the city for 3 years, and he has a rough understanding of what is what. So you can certainly be rolling the dice on whom you're going to get to do that. In the case that I tried, we had a guy who didn't work for the city whenever the work was originally done, and then had an issue with it. He was hired later and had been on for a while. And yeah, he had to testify regarding some of the elements of the water line. And he did a fine job with it, but we were very much rolling the dice, putting him up on the stand, because even with a lot of coaching, he was one of those witnesses who, like most Iowans, wants to be agreeable, wants to be nice, and
Mhm.
under cross-examination, I thought was going to start saying yes a lot to the other side just to be a nice guy.
Yeah. Well,
So
and so John, if you're dealing with something, if you're drafting an ordinance that has some technical expertise requirements in it. You know, are you reaching out to experts? You know, are you reaching out to the city, you know, the city engineer or the public works director, like as you're drafting it, or what's your process?
Yeah, I would say the experiences that I've had that come to mind where we have needed that sort of technical capacity, both the cities that I've worked with through my firm have outside engineering counsel that are my word on retainer, you know, that we're constantly dealing with the same engineer. So I acknowledge that's a privilege that sometimes smaller communities don't have. So I'm pretty well engaged with them through it because frankly, I'm probably going to need to turn to them in the first instance for those technical terms or criteria or whatever it is we're going to need to, because I wouldn't have that expertise right off the bat unless I'm going to pull something from, you know, the Code of Federal Regulations, just hypothetically, you know, unless there's some other body of work that I could instantly tap. But yeah, if it's technical, I'm going to be turning to the experts right off the bat. Because I don't want to figure out at trial that, oh, I just screwed this up, you know?
Yeah. Well, and so I was going to ask you also, John, another thing that Tom mentioned was, you know, drafting with the judge in mind. What are your thoughts? You know, what are you thinking about if you're drafting something and thinking about a judge looking at it? What are some of the considerations you're looking at?
Well, I think it's that whole, how would a unbiased person who wasn't part of the process, have I got everything on paper here? Does it integrate with the rest of the Iowa code, for instance? Just to make sure that, you know, somebody who comes to it new could read it, understand it, see how it interfaces with everybody's existing obligations. Um, and just with that in mind, you know, the judge doesn't have the background that you do. So you're gonna have to make sure it's all on paper, you know, so the
Yeah.
judge can see it.
And Tom, I wanted to ask you about background, and I guess I should say, Your Honor, I want to ask about backgrounds for one of our state's newest magistrates, right?
Yeah, probably the newest. That's right. Like
So
hours. So
so congratulations on that. So, you know,
thanks.
now, as you're going to step into a magistrate role and be thinking about these things, and based on your other courtroom experience, what do you think about in terms of like judicial backgrounds when you're preparing ordinances or when you're preparing to try, you know, a municipal case?
Mhm. Yeah, I mean, I think you almost have to draft to that judge who has absolutely zero interest in your subject matter, because you'll run into him, and I think it exists for all of us. I mean, there's subject matters that if I was going to be handling them, it would be like pulling teeth for me to work on a case on those subjects. And just hang on a second, I'm in a small town. We're getting a train. Just a second. Uh, as soon as I speak, it's gonna blow its horn. So I have had a few friends in the practice who they have zero interest in construction, but you know, my dad was a contractor and I grew up in the trades, et cetera, and I tend to kind of geek out on the construction stuff. Uh, I will often think of them, and if I'm drafting, how would they want to read it when they have absolutely zero interest in being involved in it? So that comes back to kind of explaining the terms in more detail, taking out technicalities and defining them. Um, the other thing you may want to always keep in mind as well that can really bite you is the parole evidence rule. So, you know, if we're only going to look at the document from its four corners without anything else coming in, if the terms are not ambiguous, you may not get the opportunity to bring in extrinsic evidence to try to explain what a term actually means. So you want to make sure you get it right when you do define it, because like you said, it could come back to bite you in that you might not be given the opportunity to bring in extrinsic evidence to explain it.
And then um another audience that we haven't really touched on, and I want to make sure that we cover it, is, you know, it especially if we're talking about like municipal infractions and nuisances, things like that, is drafting with the defense in mind. Tom, do you want to talk about that a little bit? You know, like because I think we've probably all also have been on the other side of city litigation where we're representing a property owner or something like that. And so what do you think about when you're drafting, when you're looking at what the defense might be looking at?
Yeah, so I guess I have to kind of be careful saying this, but I think the primary or the majority of the litigation that I've done related to cities is probably on the being outside of the city. So not necessarily defending the city, but bringing claims or suit against the city. So yeah, that's that's actually probably my primary drafting lens, is trying to step back and say, okay, if I was going to bring a claim on this, how am I going to use this against them? How am I going to put them in the corner with their own language? So you do have to be a little bit careful in your drafting that you don't inadvertently box yourself into something that's, say, impossible to meet, in that, if you set up timing requirements in your ordinance that don't actually work. I think some of us, it's very easy to forget that council typically works in about a 30-day cycle, and things have to be published for certain things to happen. And we forget that we need to build those time periods in and not pinch our clerks with time and make it impossible for them to actually get something done, or that they're always, running behind on stuff that needs to be done for the work, and then inadvertently creating risk for the city in doing that.
Yeah. And I think uh, from my perspective, when I'm looking at some legislation, especially if it's something that somebody else might have done like the first draft on, um, and with contracts too, I think I'm contrary by nature, probably, which isn't surprising. Many of the people on this call who've worked with me and know me. I think John has referred to it as skullduggery in the past. Um, but and don't worry, I'm getting repaid by my kids being the same way. So but I think anytime I'm looking at something, I'm always looking at like, how can I get around this? If from a drafting perspective, like where are the holes that somebody can evade what we're trying to implement here? Um, and I guess I should be grateful that that's kind of my natural disposition, is like looking at like where are the loopholes here. But I think it really does help when we're drafting legislation to think with that mindset. John, are you doing that as well?
Yeah, no, I think for sure that if you, especially on the contract side, I just think you have to keep asking yourself, is this clear enough? Am I creating an inadvertent loophole? Um, whenever I'm drafting a contract, for sure, that always comes to my mind, is how could they try weaseling out of this?
Yeah, and I'm glad that you mentioned contract, Sean, because I thought this would be a good segue to go from ordinances to contract drafting when we're talking about, drafting with the defense in mind, or trying to avoid loopholes or cutting out those kind of things. So one of the things that we talked about in our preparation for this was best efforts clauses. The city shall make best efforts, or developers shall make best efforts. John, what do you think about best efforts clauses? Both from
I
a
hate them. I hate them. And I relayed to the group that there's this Contra versus Penn's case decided by the Iowa Supreme Court. And since we're getting CLE, I'll actually give you a site here. It's 989 Northwest 2nd, 150. And the story is about a school principal and a Catholic priest, and she gets fired. And as part of it, they entered into this mediation agreement that they would support each other, and vague esoteric terms that the Iowa Supreme Court basically says, this isn't even an agreement you can enforce. And I think to me, it parallels those best efforts. And I know that's a case about Catholic schools, but trust me, if you read this case, substitute mayor, city administrator, city clerk. We've seen it before where, the wheels fall off the wagon professionally. Somebody gets entered into a performance improvement plan. You got to read this case though, because it really shows you they go all the way to the Supreme Court and they say, this thing isn't even enforceable. So yeah, best efforts, EU.
So what do you do instead of you know, instead of best efforts clauses, what's your drafting recommendations?
I like to build in concrete metrics, what will they do? Will they, you know, deliver X amount of materials, or that they'll spend X amount on the infrastructure and have it be certifiable that, that they just didn't blow $400,000 in the Caymans, but the accountants can say, yes, this is a $400,000 improvement. I like concrete metrics that we could go back to actual evidence to look to and support or detract from if I have to try it.
And Tom, I'm going to guess based on your construction litigation experience that those specific metrics are going to be really important for you as well when you're drafting contracts.
But yeah, I mean, those vague terms are $20,000 terms, $20,000 in my pocket because it's a jury question, and
Yeah.
it's not something you're going to be able to clear with summary judgment. So when we inadvertently use terms like that, those are terms that the fact finder is going to have to determine after hearing all the evidence.
Yeah. And one of the things that's been really interesting for me, as I've focused more on drafting, is sorry, I'm having a little short circuit here. Um, it's things that we think we know what they mean, right? And we just kind of take it for granted, and that people know what this means. Like, but then when you get into it and really try to see kind of how it plays out, you realize that we might have had a totally different understanding of what those things mean. So for example, one of the things I was thinking of is, a lot of development agreements I work on, we have requirements for a deadline for commencement of construction, and making sure that that's a really well-defined term. What does commencement of construction mean? Because does that mean earthwork? Does that mean pouring footings? Like where, and so making that clear. And I'm sure you guys can all think of other examples of things where we think we know what something means until we go to actually see how this contract is going to play out, and put it into practice.
Right. That's right.
Tom, I wanted to talk, John talked about kind of that Contra versus Pins case, and he mentioned mediation. What do you think about putting dispute resolution mechanisms in your contracts?
So do you mean arbitration terms in the contracts?
Well, that's one of the things I wanted to talk about is, when what are the different options that you consider? When do you use arbitration versus mediation? Like, do you do mandatory alternative dispute resolution as a condition precedent? What are your just kind of thought process in general?
Sure. So my personal preference, and a lot of times I find that and I think everybody on the call probably knows this if they've gone through this process, that you get the contract in from whomever it is that's going to be working with the city or proposed to work with the city, and you go through it and you almost have to pick your battles. Like you review it and you're like, oh man, there's like 12 things here that I want to change. I think out of the gate, the Iowa title standards, I think it's rule 1.1 is like who's going to actually object, to kind of like force lawyers to take their belt and suspenders back off. And that's, I think, a good perspective when reviewing the contract, that, okay, what's really the worst first? And of all these things, are there some of these things that this is never going to go wrong? It's not actually a big issue, even though it bothers me. I do think that dispute resolution, or what's going to happen in the event that they do get in a fight, is probably top of the list. And I think what I'm looking for, number one, is limitations on liability, because it still blows my mind how many contracts come across my desk for review as though they're just going to be rubber stamped by the attorney, and damages are limited to the fee that's going to be paid to the vendor. So that they're saying, even if we completely blow this $1 million project, we're limited to the $15,000 that you're paying us for these design drawings or whatever it is. That one's probably the primary one that I've consistently entrenched on, that I won't let that go past me without council approving that specifically, after the mayor getting a written opinion from me about it and what that means and how this could actually play out. And it's at that point that somebody within the outside my office breaks. Like, you're playing chicken, and they finally like, okay, fine, we'll release. So I haven't had that come to a full head where somebody's like, no, we're putting it in front of the council. Like, our liability is limited to our fee. Typically those, excuse me, those vendors will back off of that. So I get those stricken completely, typically, out of the contracts that I'm working on. The second one, my preference is that things will be resolved in Iowa District Court. And that's just because that's my comfort zone. And I know that if something comes up, I'm comfortable out there in that arena and handling it. Whereas if you get out into arbitration, I would have to refer it out to somebody else to do. It may be a better process. I haven't done it before. And I'm guessing John probably has a much deeper knowledge set in that. At least what I've heard ad hoc is your costs can be similar, and your results can be varied just like they are in court. But I would let John talk to that. The only other thing that I consistently look for is venue. I obviously want whatever we're going to decide in court to be right here in my home field, and in state court. I typically wouldn't want us to get removed out to federal court.
Yeah, so John, can you pick up on some of those things? I think, one of the things that we talked about in preparing for today, and Tom just mentioned it now, is venue. I think we probably tend to take it for granted that any dispute between a municipality and somebody else is going to be venued in that municipality's county, but I guess we can't take that for granted. And then could you talk about some of your approaches to arbitration, mediation, that sort of thing too when you're drafting or reviewing? I think that's a good call out too, Tom.
Sure. I'd say that I've got like a little checklist, let's say, as I'm clicking through the issues, and I leave it to the client, really. I mean, that I do like to build in the waiver of jury trial, or at least have that conversation. And when clients, I think they're thinking at first I'm suggesting some sort of political agenda, like the League of Justice and ATLA and all that. And it's like, no. Here's what it boils down to. Waiver a jury trial, I could probably try in one day that would take me 3 otherwise, but your fate's in the hands of one judge versus many. And I think if you break it down in those terms, they tend to get it. Arbitration, totally agree that, sometimes it works, but if it's an administered arbitration, AAA jams, like Tom said, sometimes your fees are astronomical, that match the lawyer fees almost. But I like to talk with the client about that. And there are ways you can get around administered arbitration. I agree with you, Gary, that I would think a municipal case would probably be tried in the county, but I try and always build in a venue provision, because even if you have venue, at least that way, then, the jury selection thing works where you're trying it in that county, but, you get a different jury pool. And I also like to address choice of law, because like Tom's saying, I get a Missouri company up here doing my sewer work. Well, is there a chance they could try dragging us into Missouri? Because you did negotiate with them over the phone, so let's just make it crystal clear that we're going to resolve that here. I also like to build in the venue provision, trying to defeat federal jurisdiction, but my understanding is it can't really do that, but I like to at least, make it look and feel like I'm trying to do that. Because I just think, although I like federal court for some reasons, it's not the place to resolve issues cheaply, I guess, for one of the
Yeah, and I would say, I've fought a venue provision in an arbitration proceeding, which was an interesting thing as well. And so because of some of these fights that I've had, that informs what I do now. And I think that's kind of the whole point of this talk, right? Is like approaching contract drafting from a litigation perspective, um, it sounds like we all agree that having litigated things can make us be more on the lookout for certain things because we've seen them come up. I think on the other hand, Tom, what you said earlier about, you can't fight every fight. You've got to put your capital somewhere. Um, John, do you find yourself when you're deciding what fights to fight, do you look at things that because you have a litigation history, you might say, that's not really a big deal. We can let that one go, or vice versa.
I think my job, and maybe mistakenly, but I always like to try flagging the issue. At the end of the day, let the client decide. And sometimes if I've got a good horror story to go along with it, like why we should start doing business before the operating agreement is signed, is a bad idea. I got some good stories for people about how that works. Yeah, if it doesn't, so I think I do like to maybe illustrate it with some real world examples, but I think at the end of the day, it's the clients. And if the council has decided, to use Tom's example, that if the council and the mayor have decided, that boy, they've just been a fabulous engineering company for us, and we never want them on the hook for $1 billion of damages if they screw up our sewer plant. That's the client's call. I can memorialize that we had that conversation, but it's at the end of the day, I'm not the one that signs the contract. I'm the lawyer whose job it is to flag these issues and let them decide it.
And Tom, do have you seen where there may be some complacency with having used the same contractor before, or the same, like they always get this form put in front of them, so we just sign off on it. Maybe they don't even send it to the city attorney because they've worked with that contractor so much.
Yeah, I actually think that's probably one of the biggest jobs as a city attorney is actually keeping an eye on what's going through the agenda to make sure that they send it to you. Because that's, I'd say 75% of the fight is that they actually send it to the attorney to review. A lot of times you get down the road and you're like, well, wait a second, did you ever send me that contract? And they're like, no. And it goes back to what you're saying, that they're like, well, we've always done it this way. Like
Yeah.
we've always used this contractor and we've always just approved it going through. We've never had an issue. And, from our perspective, obviously all we see is what goes wrong in the world in the litigation realm. So our data points are skewed, but we've seen how bad it can go wrong. So convincing them that, no, I know it costs a little bit of money for me to review it, but it's worth it to have me just take a look at every single agreement that's going to come through.
Yeah. You mentioned earlier about look, four corners of the document, that sort of thing. I wanted to touch base a little bit on when we've got multiple documents, when we're cross-referencing documents, when we've got amendments and those sorts of things. John, you mentioned closings and having multiple documents and cross-referencing documents and that sort of thing. What are you looking at when you've got multiple documents and that sort of thing?
Well, and again, this is kind of what's the word? Adulterated, I guess. I can't think of the right word, by my litigation experience, but I have had a circumstance where we had multiple agreements over one transaction, sale of a business, consulting arrangement, sale of real estate. And when there was a breach of one, we were obligated to try the whole thing to a jury because the judge took the position that it was the jury's job to figure out if provisions in document A govern part of the transaction that was in document B. And I just think it's important to somehow illustrate that these agreements are interconnected, some sort of cross default provision, as I put it, that this was intended to be a package deal to try and avoid that. But again, I think that also relates back to drafting. If I had the same, if I referenced it, the terms in document A are going to govern for document B, that we could have avoided all that. That deal wasn't put together by our office, but I just think that has always sort of resonated with me, that to try and link those documents together. So if there's a default under one, I get remedies under everything.
And Tom, how about like if you're dealing with amendments and change orders and things like that, what are you working on with your client and with the other side?
Yeah, I mean, for the most part, as we get going, I'm relying more upon whoever the subject matter expert is for what's going on. So, if we got a street project going and they're trying to modify the contract for however the work has changed, I'm generally relying upon that subject matter expert to say, is this true or what's actually going on? And what can be really difficult is keeping track of your scope and finish date, because I'm sure you've all experienced it, that the council almost resets every month, where it's like Dory and Finding Nemo. Like, we've all forgotten what we talked about 30 days ago, and we're relying on the clerk to give us an agenda to remind us of what we're supposed to talk about. It's tracking that when it comes to those projects. I'll give you a for instance. We just had one come through where I've got a city that's off of our local water. We're on rural water. Everybody probably saw, in the news about Newton raising their rates, and we're on Central Iowa water. So if we're off our own water source and all of a sudden, potentially our water rates are going to, go up by 8 times, and we've got a water project in process, well, we want to make sure we hit that stop date. Well, a lot of us had sort of forgotten that stop date was going to hit right about the time that water rates were probably going to, and suddenly 15 days mattered when it came to a change order. So it's also tracking that timing when it comes down to projects.
Hmm.
So
Yeah, I was I appreciate that you covered that. I was thinking about, making sure that we always have change orders in writing, because I'm sure that we've all been involved in that one way or another, where we're fighting with the contractor, or we've represented the contractor against the city about getting paid for a change order that wasn't in writing, or maybe it wasn't signed off by the right person with the right authority. Um, that sort of thing. Um,
one thing, it brings up another just almost related topic that I've found is very helpful. Uh, Sometimes I'll have clerks who've been in a role for a long time and they know the process, but with everything else they have going on, especially this time of year when they're dealing with budget, it's very easy for it to sort of fall off their sort of what they're seeing day to day. So what I've started doing is, if we have something that isn't going to be able to get done at the next council meeting, if it's going to take 2 or 3 council meetings, I've been putting a cover sheet on it with, at this meeting, we're going to do this. At this meeting, we're going to do this. At this meeting, we're going to do this. So that the clerk can go through and check off, okay, this is next, this is next, this is next. And we can both look back to it and say, okay, you put out the agenda, but you didn't have this on there. Just go copy and paste it off. And for the clerks who maybe are new at the role, I'll even put in for them, here's what the motion needs to be. Here's what the language of the motion needs to be, et cetera, so that every step of the work is done for them and they don't have to try to think about, wait, now what was the process on selling real estate or whatever it
mhm.
is, that it's just set out there for them as a checklist at the beginning of the documents that I'm drafting for them.
Are you putting like publication notice dates and things like that in those as well for to help them track them? If it's like a
No,
hearing that you're setting, or
no, I don't get that specific
okay,
necessarily, but that notice needs to be published, for
okay.
instance.
And so John, that I wanted to ask you, based on what Tom was talking about, how important is it that we draft, whether it's ordinances or contracts, that we draft without giving consideration to institutional memory? Because I think a lot of times we might be we might be prone to say, oh, well, the clerk's been here for 30 years, they know what they're doing, or that sort of thing, and so we might rely on institutional memory too much when we're drafting something. What do you think about that?
I would agree with, I think, Tom's earlier comment about the parole evidence rule. And I guess I learned the phrase, if you write at all, write it all. And I think that avoids the institutional memory problem, because, like Tom's saying, it seems like with your city staff, you have at least in the smaller communities, it seems like we have either a high concentration of clerks who's been there 30, 40 years, knows everybody in town, or they've been there less than 2 years coming from some other type occupation,
Mhm.
So you got to kind of account for both of those. And I think by trying to build it all into the ordinance, the contract, a procedure, whatever it is I'm trying to write for these folks, that I'm not really leaving anything to guess or chance,
Yeah. Another thing I wanted to make sure we talk about, since this is a litigation and drafting CLE, what are we doing about duty to defend, indemnity, recovery of attorney fees, those kind of provisions? What are you guys doing with those? What are the main things to keep in mind?
Go
Uh,
ahead, John.
Well, from my perspective, I like to certainly make sure that we address that issue. I think the other thing, and again, since we're a continuing legal ed, let's toss out a citation here. How about 783 Northwest Second 459? It's Nevada Care versus Iowa DHS. And basically what this case says, the Iowa Supreme Court says, is that the term indemnity does not relate to bilateral attorney fee claims. So if you're using the phrase, you're going to indemnify us, that bespeaks defending you from a third party claim, not a prevailing party gets to recover fees. And I think that's a big nuance. I like to build in the recovery of attorney fees in the event of a dispute, prevailing party wins, because I think, not that I think that's going to happen. We'll come back and talk about Standard Water versus Jones some other day, but you got to build in that provision, because I think it helps people reorient themselves to try. It forces a resolution instead of doing it in court, because the attorney fees really can be the atomic bomb if it gets out of hand.
Yeah. Tom, what about you?
Absolutely. I mean, if a new client's coming in and you're reviewing a contract, the attorney fee provision, I would agree with John's term, it is the atomic provision. And once the client finally grasps the weight of having to pay the other party's attorney's fees, that can make even the most unreasonable client pretty reasonable. But also it can make you a huge hero, because I think that's a lot of clients who come in are like, well, do they have to pay what I'm paying you? And, sometimes it's hard to tell them, no, you're never going to get back the money that you give to me, unfortunately. So, it can help a lot if you've got a strong case.
And Tom, given your insurance background, I just wanted to have you talk just a little bit when you're drafting of like, if you're putting in insurance requirements for the vendor that you're working with or whatever, what are some considerations that you're looking at in terms of maybe, named insured versus loss payee versus additional insured, or different things like that?
Yeah. So one of the things I'll typically do is work with the insurance agent for the city as to what terms they would like in. They can be a great resource that I think sometimes we forget about. Uh, Obviously, you want to be added as an additional insured on any projects where somebody else is coming in and working on city property. But Gary, you brought up the last time we were talking about the language that you have put in, that a standard policy form that doesn't waive municipal liability. I'm willing to admit that one was new for me. I have seen that in the practice, but I'd totally forgotten about it. And I think it's an important point.
Yeah, just to clarify, what we were talking about was with respect to 670.7, which is, allows municipalities to get insurance, self-insure, or pay into a risk pool. But it also waives immunities, to the extent that you've got that insurance for them. So making sure that in the contract drafting process, and specifically in the insurance requirement provisions, that we're not inadvertently waiving immunities by having somebody get insurance and having us as a named insured on it that might waive those immunities or something like that. So just, I think the best fix for that is, when you have insurance requirements, making sure that there's a notation or endorsement on the policy that that says that the policy there's no coverage for anything where there is immunity, you know, so that the coverage doesn't kick in unless and until it's been determined that there is not immunity. John, do you have any additional thoughts on the insurance indemnification?
No, I just think it's important that you do address that. And I, like Tom mentioned, I like to have either I reach out to the insurance agent or have the client get feedback from the agent about potential coverages. And because I think we all get in the kind of that habit about, hey, well, the last time we did this, we had, you know, X for CGL coverage and Y for workers' comp. And I just think it's good to have that conversation again and again.
Awesome. I think we're at the end of our time. I don't know if anybody out there might have some questions, and if not, if Tom or John, if there's anything that we didn't cover that you really wanted to make sure that we covered.
Nope.
No, I think what about only written amendments allowed for contracts? How about that one?
Yeah, I think that's a good reminder too. Just like with change orders, you know, if we're amending contracts, that we only allow written amendments.
Mhm.
Amanda, do we have any questions from the audience?
I do not see anything in there for questions, so I think we are good to go. I appreciate all of your time today.